This is Daniel Smith from San Diego Defenders, and today we're going to be talking about the typical misdemeanor DUI timeline, if you will. I'm asked a lot of times, what exactly happens in a misdemeanor DUI? Well, first of all, there's the DUI arrest, and we don't want to revisit that. It's not a pleasant experience. But let's just say, just for the purposes of this example, that it happened on June 1st of 2017. After you're stopped, you're given one of these, usually a temporary driver's permit. You'll see the pink piece of paper. And one of the things I really want to emphasize at the very outset, and we'll have another video on it, is that there are two parts to every misdemeanor DUI case. There's the DMV side and there's a court side, okay? So we're going to be talking about the court side of the case today, okay? So the DMV side over here, we know that just as to set your time frame, that you're given a 30-day permit, okay? That's good for 30 days, and that's in the form of this temporary driver's permit that's given to you on a pink sheet. We'll talk more about that in the 10-day time limit in which to request a hearing. So in this case, let's talk about what happens first. Well, generally speaking, you'll be given a date to appear in your first court date, and that's why I put court date over here. So let's just say that's 8/1/17, okay? So that's the first court date. What happens then? Well, at that time, a lot of people say, well, I don't know if I want to have a public defender represent me or a private attorney. If you are represented by the public defender, this is what's going to happen. You're going to show up on the first court date, and you're going to be asked to plead either guilty or not guilty. And what's really important here is that you understand that in making that decision, all that you're going to have is basically, you're going to have probably your BAC, what your blood alcohol is, and you might have a report, usually one report, perhaps two, but that's as much information as is generally there at the time of the first appearance. And you'll be asked at that time to make a decision on whether to plead guilty or not guilty. I've got all these other things over here to talk about on why you should perhaps reconsider whether you should just throw yourself onto the sword, so to speak, and plead guilty. At this point, you have limited information. You've got your blood alcohol. You don't know if that was done correctly, and there's no chance to challenge it. And you have the report that the officer's point of view. There might be the second officer, but generally speaking, it'll just be the one report from the officer and the blood alcohol. You'll be asked to plead guilty or not guilty. If you plead guilty, the ramifications down the road when you plead guilty could be felt in getting a job, in applying for a job. So it has ramifications down the road. What you'll qualify for a business license, in school, all those things will be affected by your guilty plea. If you choose not to plead guilty, to plead not guilty, you're going to be able to exercise your constitutional rights. That include the right to remain silent, the right to confront and cross-examine witnesses, the right to present evidence on your behalf. You have all of those rights, and we'll be talking a little bit about those. So what's done after that? Well, if you have a private lawyer, the first thing that you need to know is that you will not have to go to court on your first court appearance if it's a misdemeanor DUI, especially a first-time DUI. So what happens then is that there's a negotiation hearing that's set after this first court appearance, and it might be about 30 days later after your first court appearance. So let's say that this one's on 9/1/17 after that. At that point, your private attorney is going to be requesting more discovery. Discovery is a fancy way to say, well, I want this additional report. I want to know what this one says, and I certainly want to know a little bit about how you arrived at the BAC and if it was done correctly. So you might be looking at a calibration report as well. Generally speaking, it takes a while for the DA to get that information to you. So we may be going on to a second negotiation hearing. Now remember that these negotiation hearings are with the district attorney or the city attorney, whoever it may be, and we're going to be talking with them and negotiating with them on the strengths and the weaknesses of their case and the strength of our case. remember, it is their burden to prove guilt beyond a reasonable doubt, and they have to keep that in mind. So we would be asking for these calibrations, these further reports, asking for that second report of the officer. Remember, there may be one officer, two officers in the car at the time of your arrest. What's really, really important is that we may get to that third negotiation hearing, and at this time we're screaming and yelling that we want to see the video evidence. How important is that? The video evidence has changed the way that attorneys approach the defense of their clients. The report may say that the client was wobbling all over and was slurring his speech and his or her speech, and their eyes are bloodshot and red, and all kinds of misrepresentations. When you actually compare it to the video, you'll see that the officer in his report, it doesn't match up at all to the video. That gives us more negotiation power when we're over here negotiating with the district attorney or the city attorney involving your case. We're looking for some leverage in that case, in that particular scenario. You may be involved in a checkpoint. Maybe it's a checkpoint. There's a checkpoint package. There's so much discovery over here that is never considered at this first court date when you're asked to plead guilty. There's so much evidence that you don't see. You may just be seeing, again, just a limited amount and asked to plead guilty, and you may be forced to really reconsider whether you should be pleading not guilty or not. So getting back down here to the flow of how everything goes, we've got the first court date. Do you plead not guilty or guilty? At this time, we said a negotiation hearing, we're asking for more reports. We start to get more reports. We start to look for leverage again. What's so important again? The video evidence has really changed the way us defense attorneys look at the cases. Now, given all of this different evidence that we've received along the way, we may then choose to bring what's called a motion, and that's a legal motion that's in front of a judge and not a jury, in which we challenge the constitutionality of the search. Because remember that if you're arrested on a DUI, it is what's called a warrantless. There's no warrant. It's a warrantless arrest. What does that mean? Well, that means that the people have the burden to prove that there's probable cause. That means that it's entirely their burden to show that all the things that they did were correct, that they properly placed you under arrest and they had enough probable cause. So this can be brought up in a motion to dismiss. This helps your attorney gain leverage in negotiating with the DA before we finally come to some sort of an agreement where we're trying to get our client into a better position. And finally, of course, if there's another readiness hearing, we may, after this motion, depending on the outcome, set it for trial. Now, not everybody wants to go to trial, but it's important that your attorney has a reputation for going to trial and a reputation that they'll litigate the case. And that's what we have here at San Diego Defenders. We will go and leave no stone unturned, and that's what really we want to get across to you today in this very short video explaining the approximate timeline. How long does this all take? Well, you can really figure just about anywhere from about 4 weeks on each one of these. Generally speaking, we're talking about a 90 to 120 day span. It sounds like a long time, but when we're talking about the ramifications of what a guilty plea to a DUI means for your future, it's really important to think about pleading not guilty and challenging the case, seeing if there's any leverage, making sure that you can write that motion, you can set that for trial, you can go to trial, you can use this as leverage to get where you want to go, which is really here. We want to get to the not guilty. We want to get to a reduced charge. So thanks for listening. This has been a very short video. Call us at 619-258-8888. Set up a free consultation. We'll talk to you about the timeline in your misdemeanor DUI case. Thank you.